Hi aspirants, welcome to SRV's weekly current affairs for polity and international relations. Since this week we have enough issues to discuss on polity, I'll be handling only polity topics this week and international affairs will be covering exclusively in the next video. So today's first topic is anti-defection law. We have already discussed a lot about anti-defection law, but now the issue is whether the anti-defection law proceedings have judicial review or not. The answer is yes, they have judicial review. Why? When complete autonomy, when so much of power is exclusively given only to the presiding officer of the house, like the Speaker of the Lok Sabha, Chairman of the Rajya Sabha, or the Speaker of the Legislative Assembly, when they are given exclusively all the power, can it be misused? So is there some scrutinization for this? That is the judicial review. In 1992, the constitutional bench of the Supreme Court said that anti-defection law proceedings before the speaker is almost like a tribunal. So this is like a tribunal, and so it can have judicial review. And in Jan 2020, very recently, the Supreme Court asked the Parliament to amend the constitution to strip legislative assembly speakers of their exclusive power to decide whether the legislatures should be disqualified or not under the anti-defection law. Simply, whether a legislator who has defied can be punished or not. The ultimate power should not be with the speaker. And again in March 2020, the Supreme Court removed Manipur minister against whom disqualification petitions were pending before the speaker since 2017. So for 3 years, the speaker has not taken any action, just he has kept it pending. But the Supreme Court has intervened and removed this. All these data, you can use it for mains. So in the Supreme Court, in Jan 2020 and in March 2020, in twice it has intervened and got judicial review for the anti-defection proceedings. Now, what does the law say? According to the anti-defection law, we know according to the by this 52nd amendment, it's there. This anti-defection law states there is no specific time in which a decision has to be made by the presiding officer. So according to law, there is no specific time frame. This could be a prelims question, we should note. But the Supreme Court said the anti-defection cases should be decided by the speaker in 3 months' time. So the law says no time frame, but Supreme Court has iterated 3 months time frame should be given. And what is the criticism about this anti-defection law? Voters, we elect individuals in the election and not parties, and hence anti-defection law is infructuous. So what does this mean? So anti-defection law takes care of two things. One is jumping from one party to another. In that case, the person is considered to be a defected. That is fine, that is okay. The first one is okay. But what about the second one? When there is an issue and it has to be voted for in the assembly, that particular legislator has to vote according to the whims and fancies of the party which he belongs to. Though individually he does not like that act, it is not good for the people, particularly it is not good for the people of his own constituency. Even then, he has to vote according to the idea of his own political party. Else, he will be considered as a defected. So this is right or wrong. So individually, though he knows something is wrong, he has to go and vote according to the wish of the party. So this is a huge question whether this is right or not. This is why anti-defection law has been criticized. So in the comment, you can give your ideas whether anti-defection law, particularly for the second issue, is right or not, and what is the way forward. It could be really useful for your mains question. The next second issue is about the MEKEDATU issue. The MEKEDATU is a multi-purpose drinking and power project by the Karnataka government. But Tamil Nadu has rejected the idea, saying that the Kaveri Water Management Authority on the MEKEDATU reservoir issue was proposed by Karnataka. Karnataka government says no compromise on this issue, we are going to build the dam. And what is the issue here? Karnataka is supposed to release Kaveri water to Tamil Nadu from 3 different sources. One is water flowing in the areas downstream river Kabini. We know Kabini is one of the tributaries of Kaveri. Since MEKEDATU issue is going on, we have to know each and every tributary of Kabini as well. And very soon from our side we will be giving a map video completely. 1 year, the last 1 year or more, the issues related to map are going to be given as a video for those students who are going to attend the prelims in 2022. Very soon we'll be giving it. So the first one is downstream river Kabini, catchment areas of Krishna Sagar reservoir, the sub basins of Shimsa, Arkavati and Swarnavati rivers. And from all these rivers, water is coming from Karnataka to India. So, and of course, all these those things which I have mentioned here are tributaries of Kaveri as well. The second source, it is released from the Kabini Dam. The third source is water that is released from the Krishna Sagar Dam. The first source is directly from the rivers. The second and third sources are from these two dams. Now the issue is, in the case of the second and third sources which are under the control of Karnataka, water is released to Tamil Nadu only after storing sufficient water for their use. But in the first source, there is no dam at all. From the first source, there is no dam. Water directly comes to Tamil Nadu. But now Tamil Nadu state government says Karnataka is conspiring to block this source also through the MEKEDATU dam. This only with this first one source has no dam. Now they are going to build dam in this first source also. And Tamil Nadu also says Kaveri Water Dispute Tribunal and the Supreme Court have found that the existing storage facilities available in the Kaveri basin were adequate for storing and distributing water to Karnataka's proposal is not right. It is untenable because already they have enough water according to the Kaveri Water Dispute Tribunal. And moreover, Tamil Nadu is also skeptical. It is doubting that the reservoir is not just for drinking water alone, but to increase the irrigation facilities as well, which is a clear violation of the Kaveri Water Dispute Award. But Karnataka says it is only for water, drinking water purposes for in and around the Bangalore region. Now, what is the award by the tribunal and the Supreme Court? What are the verdicts given by these people? The tribunal was set up, the Kaveri Water Tribunal was set up in 1990 and it made its first award, that is the first verdict in 2007, saying 419 TMCFT of water will be given to Tamil Nadu, 270 for Karnataka, 30 for Kerala and 7 for Puducherry. But against this, the Karnataka government appealed and then the tribunal ordered that in rain scarcity areas, allocation will not be compulsory, it can be reduced. But due to the appeal of Karnataka, there was another judgment in 2018 by the tribunal which said 14.7 TMC of Tamil Nadu's water will be given to Karnataka. That is, from this 419 TMC which was given during 2007, 14.75 will be reduced. And that is going to be given to Karnataka, but the amount for Kerala and Puducherry, that remained constant. It did not change. Now the central government has said the project requires the approval of Kaveri Water Management Authority. It requires approval, so Karnataka just cannot go forward. Also, as per the Kaveri Water Tribunal final award, which was modified by the Supreme Court also, the acceptance of Kaveri Water Management Act would be a prerequisite for the consideration by the Jal Shakti Ministry. So finally the Jal Shakti Ministry has to approve it, but even before that the CWMA has to approve it. And also as per the Kaveri Water Dispute Tribunal's final award, we have to know this. We have that is the acceptance of CWMA is necessary. So they can, the Kaveri this MEKEDATU issue cannot proceed without the approval of the CWMA, and moreover Tamil Nadu is obstructing it as well. We have to wait and see what happens. The next topic is about the privilege motion. So it's an issue because 4 Telangana Rashtra Samiti members in the Rajya Sabha have submitted a privilege motion against the PM. They have submitted a breach of privilege motion against the PM, saying that some of his remarks against the Andhra Pradesh reorganization bill are breaching his privilege. So what is a privilege? Parliamentary privileges are certain rights and immunities enjoyed by members of parliament individually and collectively so that they can effectively discharge their function. Simply, an MP can talk whatever he wants in the parliament, that's all. If he is restricted of that, democracy is going to be under trouble. So he can talk anything and he can give any records there. But sometimes if they talk something or if they give a record and which is not true, which is a false statement, that time they can say that they are breaching the privilege given to them. You are given a privilege that you can talk anything in the parliament, you will not arrested for that. But what you are doing, since only you have such a privilege that you can talk anything there, you are giving false statements. In that case, in the parliament itself, they will move a motion called as breach of privilege motion. So how do we get this power? Article 105 of the Constitution gives this power. It says freedom of speech in parliament and the right of publication of proceedings. Both are coming from Article 105, which is an important prelims question. And not just the article in Constitution, the Code of Civil Procedure 1908 gives some power. That is freedom from arrest or detention of members under civil process, not criminal process, but only civil process during the continuance of the meeting of the House or of a committee thereof, and 40 days before its commencement and 40 days after its conclusion. So parliament is in function. So during the functioning of the parliament, the person cannot be arrested for a civil purpose. Even 40 days before the commencement of the parliament, he cannot be arrested. And 40 days after the commencement of the parliament also, he cannot be arrested for a civil proceeding. Because if you are going to arrest an MP for a simple civil proceeding, he cannot go to the parliament and he cannot do his functions as a legislator, which means the country's functioning is going to be under stake. So that is why these special privileges are given. If you or me do something wrong, a civil wrong, we could be arrested, but not an MP in the parliament. They have a special privilege. And if these special privileges are misused, in that case, breach of privilege motion is passed in the parliament, and then if it goes right, actions will be taken. Now how it is done? A notice is moved in the form of a motion by any member of the parliament against a person who is found guilty. So the first point of action is the speaker or the Rajya Sabha chairman who will scrutinize this. They can directly decide on the privilege motion themselves or refer it to a privilege committee. So you have a separate committee called privilege committee in the parliament. So the speaker or the chairman, they can directly decide whether it can be accepted for a privilege motion or they can give it to a privilege committee to examine it. So if the presiding officer gives consent, the member concerned is given an opportunity to make a small statement. So even if the speaker or the chairman, they say yes, this can be accepted as a breach of privilege motion, that particular person who is accused, in our case, in this case, let us say the prime minister is accused, and now let us say the speaker accepts this privilege motion, and then the prime minister will be given a chance to give a short statement to prove that he is not guilty also. And it's not just here, it not just settles with the members of the parliament. These privileges are given to other people also who are entitled to speak and take part in the parliament. For example, let us say the Attorney General of India. Attorney General of India, he is not a member of the parliament, we should note that. But at the same time, he has the right to speak in the parliament. So for that sake, this right, this what is this? This privilege is given for the Attorney General as well. But something to be noted here is this privilege is not given for the president. So what is parliament? If we ask the question, it is the Lok Sabha plus the Rajya Sabha plus the president. So clearly the president is part of the parliament itself. But even then, this right of privilege is not extended to the president. He does not have it. But at the same time, separately, Article 361 of the Constitution provides for the privilege of the president. So we know that Article 105 gives the privilege for member of parliaments and those who have right to talk in the parliament, including the Attorney General. But for the president, a special article gives this right for him, Article 361, and not Article 105. Next one. The next issue is Supreme Court refuses a plea for including madrasas and Vedic schools under the Right to Education Act. It says Right to Education Act of 2009, it already excludes Vedic Padashalas, Madrasas and other institutions imparting religious education. The court says the exclusion of these institutions was specifically inserted in the 2009 Act by the amendment of 2012. So they are specifically saying that Madrasas or Vedic Pathshalas or Vedic schools are not coming under the Right to Education Act. So definitely we cannot accept this plea. This is what the court says. But the petitioner, he says the court may declare sections 1 clause 4 and section 1 clause 5 as arbitrary and irrational. It says it is irrational. What matters if what type of education? It is right to it is the freedom. It is the right to freedom of that particular child to have any type of education. Why don't you include this education at all? It is irrational. That's what the petition says, but the court is not ready to accept it. So let us see what is section 1 clause 4 and section 1 clause 5 of the Right to Education Act. The section 1 clause 5 of the Act states, nothing contained in this Act shall apply to Madrasas, Vedic Pathshalas, Vedic schools, educational institutions primarily imparting religious instruction. So the section 1 clause 5 abruptly excludes all these things. And section 1 clause 4 says, subject to the provisions of Article 29 and 30 of the Constitution, the provisions of this Act shall apply to conferment of the rights on children to free and compulsory education, but not for religious education. Now, what is Article 29 and 30? We know it contains provisions to secure the rights of minorities and minority-run institutions. Particularly, the Articles 29 and 30 are to preserve the culture of the minorities. It is cultural rights. So, Article 30 clause 1. This Article 30 clause 1, it recognizes the linguistic and religious minorities, but not those based on race or ethnicity, of course. It recognizes the right of religious and linguistic minorities to establish and administer educational institutions, to recognize the role of educational institutions to preserve their distinct culture. But the question here is whether a majority community can establish an educational institution. Yes, they can establish educational institutions, but they will not have any special rights which is given under Article 30 clause 1 clause A. So this clause A gives some special rights for the minorities alone who have educational institutions. So what are those special rights here? If the property of a minority education institution is taken by the state, a compensation has to be provided to establish institution elsewhere. It is not just providing some monetary compensation. The compensation should be enough to establish an institution somewhere else. Under the Article 15 clause 5 of the Constitution, minority education institutions are not considered for reservation. They don't come under the reservation ambit at all. Under Right to Education Act, minority education institutions are not required to provide admission to children in the age of 6 to 14 years up to 25% of the enrollment reserved for economically backward section of that society. So up to 25%, not even this compulsory 6 to 14 years of education is considered under the Article 15 clause 5, where special rights are given for the minority education institutions alone, not for other institutions. Now there are certain cases involved. If you can try and remember these cases, you can use them in your mains exam. Probably we don't think such cases are asked in prelims, but in mains, if you can quote these cases, your score is going to increase. In Stephens versus Delhi University case 1992, the Supreme Court has said minority education institutions can have 50% of seats reserved for the minorities alone. And in the TMA Pai and others versus State of Karnataka and others 2002 case, the Supreme Court has said minority education institutions can have separate admission process, but it should be fair, transparent and merit based. and also separate fee structure but should not charge capitation fee. These are some important informations here. This could be asked in a prelims question. That is, there are certain conditions. So you can have a separate admission process which is not in par with the national education policies being followed or the state government's education policies. You can have a separate admission process, but it should be fair, transparent and merit based. And moreover, your fee structure could be completely different, but it should not be including a capitation fee. These are to be remembered. And that's it for today. Jai Hind. If you like the content, please share it with your friends as well. Let us learn and grow together.